Are you Michaela Collier? And so this is 24 DCCR 0751. Ms. Collier is on probation for the second-degree felony offense of aggravated assault with a deadly weapon. That probation was from October 7th of 2024, and we did a 10-year term in prison that was probated for 10 years, which we have now, I think, figured out, and I don't disagree with Mr. Kimler that this should have been a deferred probation instead of a straight probation. I'm going to do a little research on that though after today and figure out exactly, you filed a motion to quash. I'll take a look at that and figure out what our options are as far as that issue. What we're here for today, regardless of all of that, Ms. Collier accepted responsibility,
Yes.
pled guilty to the offense, whether it was a straight or deferred, took a probation. The motion alleges that she's violated her probation by committing a new offense of assault causing bodily injury October 17th of 2024, not mailing in or reporting online for several months, not reporting address change, and just a little bit behind in court assessed fees. And Mr. Kimler has asked that a bond be set. Currently there's no bond in this case. I think she's obviously entitled to one based on the nature of what's going on. Mr. Nichols, what's the state's position?
I just asked that the bond be sufficient to secure her appearance in court, Your Honor.
What's the status of that?
I believe it's a pending misdemeanor assault.
It's out of Carroll.
Is it?
It says Jefferson County.
Is it? Okay.
Yes.
Did that happen in Jefferson County? The UK? Okay, yes, it's just.
So that's still pending?
I looked at it yesterday, Judge. I think it is still pending, unless I'm mixing it up with another similar case.
So, Ms. Collier, I'm just going to ask you a few questions so I know some information before I do this. Best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. So, Ms. Collier, where, if released, will you be living?
2730 Sweet apartment 8. My boyfriend bought me an apartment because I was coming here and myself in.
Speak up.
My boyfriend had bought me an apartment because I was coming.
Hold on a second. Y'all, I'm having a hard time hearing if today for some reason, and the voices are low, so
Speak up.
Swigum apartment A?
Yes, apartment
Okay.
8.
8. Gotcha. Okay. And who else will be living at that apartment?
Jamal Guidry, my boyfriend. He bought the apartment just so that I could come move back.
And is Mr. Guidry in any kind of trouble?
No, ma'am. He's clean, no criminal record, no none of that. He's a working man. He comes from.
Is that in Port Arthur or Beaumont?
It's in Beaumont. It's Mosaic Apartments.
Okay. So where were you living?
2010 East 7th Street, my mom's house, where I had reported to my probation officer in South Dakota.
Oh, in South Dakota.
Yes, ma'am.
Okay. All right.
I think she had permission to be there.
Yeah,
Yeah. She was reporting here online. That's why I knew she was somewhere else.
and I have a.
And good morning, probation's here as well. It looks like other than failing to report online for the beginning of this year, or last year, we're 2026, 2025, an address issue, other than that new offense, things were going okay where she was in South Dakota?
No, ma'am. She, South Dakota actually rejected her case because she was not on the list of the original address, which was your
My
mom's.
mom.
Right, so they rejected her case. She had to come back. She came back, but then she went back without permission. That was
The problem, okay. So here's what I'm going to do, Ms. Collier. I'm going to grant Mr. Kimler's motion to set a bond in your case. I'm going to set the bond in your case. Well, let me get a little more information so I can make sure I have all this right. Who is the complaining witness in the 2024 misdemeanor
It's
case?
a acquaintance, Judge. I don't think it was a family member. It was somebody she got in an altercation with and actually drove over with her car. Was the original offense.
What's the name of that person? Do we know?
I have it right here. Daisy Anna Brown.
Say it again.
Daisy Anna Brown.
See. All right, so here's what I'm gonna do. I'm not going to make the bond real high because I am also going to require that you get a GPS monitoring device, and so that obviously we'll know where you are with some other conditions. And so I'm going to set the bond in your case at $10,000, okay? I'm going to order as a condition of that bond, if you make it, that you remain in Jefferson County, Texas. You cannot leave Jefferson County, Texas. Hold on, just listen, okay? You will be required to wear a GPS monitoring device. You will be reporting in person here in Jefferson County. There's no leaving the county. If you leave the county, you're back in jail and we're on a whole different path. Do you understand? You will live at 2730 Sweet Gum, apartment 8 in Beaumont, unless you give notice to probation and they let me know and I approve somewhere else for you to live. So you can't just move and then tell us. You need to let them know, and then they'll let me know or let Mr. Kimmler know. I want to know where you're going, who you're with, and those kinds of things. On probation, you cannot be around anybody else that's on probation or charged with an offense. And so you need to get a job, go to work, go to probation, go home.
Yes, ma'am.
That's it. Do you understand?
Yes, ma'am.
And then I will set the case for just another, maybe no more than a normal reset. And we'll take a look at what our options are on getting the issue worked out, if possible, with regard to the type of probation. And so, Mr. Nichols, if you'll do some research into that as well, see what our options are, and I'll get Mr. Florence to take a look at it as well. All right?
Your Honor.
You can go back with the bailiff.
Thank you.
You're whispering again.
I'm sorry, Your Honor. We're asking for a bond on this.
Yeah, that's what we're here for. Are you Wayne Cummings? Mr. Cummings, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so this is cause number 18-29640. Mr. Cummings is on probation for the offense of manslaughter. A motion to revoke community supervision has been filed, and Mr. Kimmler's filed a motion asking that I set a bond. Looks like the date of the probation was from October 22nd of 2018. A 10-year term in prison, probated for 10 years. New offense alleged in that motion is a driving while intoxicated, October 5th of 2025 in Orange, at a location other than his residence at 4:15 a.m. on October 5th in Orange, and that he was intoxicated on that date and behind in court-assessed fees. Mr. Kimmler, you may proceed.
Your Honor, first observation is Mr. Cummings did turn himself in. This wasn't one where he headed for the tall grass when he found out he had an MTRP. He did turn himself in. I understand, I think this is straight probation. It's not entitled to a bond, however, with the Orange, and of course, Mr. Smith is familiar with Orange County. It may be a while before that DWI is filed, so I don't know how long it's going to take for the state to be in a position to try to prove that up. So we're just asking for a bond pending disposition if they're going to proceed on the DWI. Obviously, they could proceed on the administrative violations.
Mr. Smith?
My concern, Judge, is Firstly, the manslaughter was basically a DWI where he hit somebody and killed them. He had issues, safety was a recommendation for the original probation to go through in the PSI. This new offense, the allegations apparently show he was out at 4 in the morning and was intoxicated driving. And so I would have reservations and concerns. I think there's been a relapse, and he's not actually entitled to a bond. It's a straight probation versus deferred. So we would be opposed to a bond.
Do you know the status of the Orange County case?
I don't judge.
I don't think it's been filed yet, 100%. I checked before.
If it was just knowing how they work over there, if it was just alcohol, they would have already probably had the results.
Y'all are just guessing. Is there a way for us to find out? Is there any kind of hold on him?
If you want to hold it for a minute, I can call the DA's office and find out.
Yeah, let's do real quick, and we'll just do it real quick. Just have a seat, sir. And there's not. I'd like to know what that is. Good morning. Are you Marquise Jones? And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, in cause number 21-37263, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 23rd of 2022 for the offense of theft of material, and that was a state jail felony, and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of evading arrest on June 20th, 2024 in Harris County, Texas. And is that true or not true? And then count 2 alleges that you were at a location other than your residence at approximately 1:30 a.m. June 20th of 2024. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And did you plead true to those counts because they're actually true? Speak up, please. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And I think I said your plea of guilty instead of true, but your pleas of true. Anyway, all right, so I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of material, aluminum. I guess it goes on, aluminum, bronze,
Aluminum,
copper.
bronze, copper. They were cutting catalytic converters.
And so find you guilty and sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir, and thank you for being here, sir. All right, again, you're Wayne Cummings, right?
Yes,
And Mr. Smith, what did you find out about that Orange County case?
Spoke with staff at the district attorney's office. They have not.
Can y'all stop? If you're talking about a case, keep it down. If you're not, please stop.
They have not received the case. Found out the agency, it's Orange Police Department that made the arrest. He said, the person I spoke to said that it normally takes about 6 months to get this done. It's gonna be a misdemeanor, it looks like, based on looking at criminal history and his PSI, and they thought that as well.
Okay. So then, that's really the main issue, obviously, in this motion, out past curfew and that
That was the thing that
offense.
concerned me, was the time of day.
Sure, so here's what I'm gonna do. I'm going to grant the motion to set a bond.
Scram device, Your Honor, or?
Hold on. I don't want Mr. Cummings driving at all, right? So that's gonna be a condition of this bond. You're not allowed to drive a vehicle ever while you're on this bond. No one's vehicle, not yours, not anyone else. For any reason, you're not allowed to drive. Do you understand? I'm going to set the bond in your case at $25,000. Again, condition of that bond is no driving. Also, a condition of that bond is going to be that you are required to wear a GPS monitoring device at all times and remain, do you live in Orange or do you live in Beaumont? Or Port Arthur? Where do you live?
I was in housing out there in Orange.
When you go home, if you make a bond, where's home? Where are you going to be? In
Maybe-
Orange?
Maybe. I'm trying to figure out, I don't know where I'm gonna go.
Okay.
I can get back with you on that.
So what I'm gonna do is require a GPS monitoring device and that you remain in either Orange or Jefferson County. You need to let your bondsman know they're gonna require an address so that I know where that GPS is you're supposed to be. And obviously, you're still on probation. The same curfew applies. You're not to be out of your house past 10 o'clock at night. And also going to require I think it's probably because I'm requiring the GPS, a little more cost effective to do the handheld breathalyzer. So you're going to be required to have the handheld breathalyzer. You are not to drink alcohol ever. If you test positive, if you miss blowing throughout the day, it's a thing where you have to blow randomly throughout the day. It's going to tell you when. Probation and your bondsman can go over that with you also. But if you test positive for alcohol, your bond's going to go right back up and you'll be back in jail. Do you understand?
Yes,
If you need some help, you're still on probation. Go to your probation officer. Say, look, I relapsed. I was drinking. What can I do while you're out on this bond if you make it? Okay? Anything else?
You have to report to probation.
Anything else?
No,
Anything else, Mr. Smith, that you can think of?
You have to report to probation.
Okay, you can go back with the bailiff. All right, sir, you're Michael Brasher. And this is 23 DCCR 0944. Mr. Brasher's case is set for trial to begin with jury selection next Monday. And what is the announcement?
State's ready for trial.
All right, then this will be the number one case. There was only two or one really left over from yesterday. And so I can go ahead and let y'all know it will be the number one case. After today, there will be no plea agreements. If something gets worked out before you leave today, let me know. Otherwise, we'll see y'all Monday and we'll begin jury selection at 1 o'clock.
Yes, ma'am.
All right, thank you. You can go back with the bailiff. Good morning, sir. Are you Michael Victoria? And this is cause numbers 21-36410 and 21-36411. Mr. Victoria is charged with murder in each of these cases. Mr. Matusko, what is the announcement?
Your Honor, at the last setting, I informed the court that it had about 48 DVDs in this case.
Right,
This morning I checked, I'm on 23, I'm about halfway there, and that also includes hundreds of documents I've gone through. So I'm getting close, but I would ask for one more regular recess.
Mr. Smith?
Judge, I completely understand this is almost a bucket just with the two cases. So
Right. All right, so I'll do a normal reset to give Mr. Matuska some time to complete all of that discovery, come out and visit with you about it. We'll see if we can get an announcement at the next court date possibly. Okay, you can go back with the bailiff. Okay, give me just a second. Hold on. Anna, I just got, do I hit yes or no? I got a script error. Just exit out.
No. Send to your office through email. Now, DC will send it to you.
Here, I'll print out a copy for,
I can summarize it. Normally, after I e-file a copy, I email it to the court and copy the court on it. I just didn't get a chance to do it this time.
it's okay. We'll take a look at it real quick. So, sir, are you Calvin Hawkins?
No.
And this is 24 DCCR 1160. Mr. Hawkins is charged with unlawful possession of a firearm by a felon. Looks like the bond is currently set at 100,000. There was a court date, March 31st, that Mr. Hawkins did not appear, and so there was a bond forfeiture, and the bond was raised to 100,000 at that time based on that. And then Mr. Macon looks like was hired, filed motions and letter of representation in October. So here is Mr. Macon, the state's. I don't know why it's printed like this. Oh my gosh. No, I mean, I printed 2 copies and it printed like 1122. It hasn't done that in the past, ever, when I've never seen it do that. It never has done it to me.
Thank you.
Okay, so the state filed a reply to Mr. Macon's motion asking for a bond to be reduced. Let me take a look.
There's,
Go
just
ahead.
by way of summary.
Yeah.
Page 2, it's referring to the defendant's criminal history, and also on page 2, the very bottom refers to jail write-ups, and that's essentially the state's, what the state would ask the court to take into consideration if you are so inclined to reduce the defendant's bond. Criminal history, including 4 previous felony convictions, 1 for burglary, a felony theft, a possession of cocaine, and a felony marijuana. And he's been also written up by jail staff for possessing contraband in jail and failing to follow and disrespecting the rules of staff in the jail.
All right, thank you, Mr. Coleman. And I am getting a copies of any jail incident reports.
I've attached a couple of those reports to my motion for my reply.
Oh, okay, I see those. Would you check and see if there's anything since December 3rd, please?
Yeah, ma'am.
Okay. So the prior, all of those offenses, the burglary, theft, possession of cocaine, and felony possession of marijuana, all of those are felony offenses and convictions, correct?
That's my understanding.
Mr. Macon, you may proceed.
Yes, Your Honor. First off, Mr. Hawkins, you're unable to make the 100,000.
Hold on just a second. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead. I'm sorry, Mr. Macon.
Would you state your name, please? And you've been unable to make the $100,000 bond, correct?
Yes.
Okay, do you have family and friends that were a reasonable bond be set that you could make?
Yes.
Okay, now you understand you're from Florida, so if you make a bond, you'd have to stay in Jefferson County.
Yes.
And you have friends that you would live with here in this area?
Yes, sir.
Okay. Now, you turned yourself in once you learned there was a warrant for your arrest, didn't you?
I didn't know I had a warrant for my arrest.
But when you learned, you turned yourself in.
Yes.
Okay. Do you understand that you also would be required to wear a GPS monitor and probably a drug patch or anything like that? You would comply with all those conditions. And whatever other conditions you were given, you would do. Okay, now, with respect to this contraband, the September 26th, they were Tylenol pills, right?
Yeah, I just didn't take it.
You were given them by the jail staff and didn't take them. Then December 3rd, and December 3rd incident was you having your jumper down or something.
Oh, man.
But you didn't have a knife or anything like that or anything like that. In other words, they wrote you up for refusal to follow written or oral directives. But you didn't jump anyone or beat them up or anything like that.
No, I don't even recall that write-up. I didn't know it.
Okay. I have nothing further on.
Okay, I'm reviewing the probable cause as well. Give me just a second.
Your Honor, I could ask some questions.
I need to read the probable cause, if you'll just give me a minute, please. Is there anything else, Mr. Macon?
Your Honor, Damash, and I'm probably mispronouncing this. Damashi, is that how you pronounce that? Demisha Jones is a witness who's going to say the gun was hers and she put it under the seat.
It's not what she told the officers that day.
And that's what she's going to testify to anyway.
Okay. So for the record, I have reviewed the probable cause affidavit. I also did receive notification, and if anyone has questions for the bondsman's representative is here today. And her company had to hire a bounty hunter to locate and get Mr. Hawkins after that bond forfeiture. So obviously, to me, that would indicate that he was not keeping up with his bondsman, and otherwise he would have. If you bond out, you've got a bondsman. You check in once a week. You would know you have a court date. If you miss a court date, you would know there's a warrant. So there's that issue as well. Mr. Coleman, what's the state's position?
The only thing I add, Judge, is that he's subject to a habitual offender enhancement, making him $25.99, Judge.
Okay. At this time, based on the nature of the offense itself, the unlawful possession of a firearm by felon, the probable cause affidavit, and the information that was in that, there were 3 vape pens found as well. I know obviously none of this is proven, but it is important to know, everybody had different opinions, or the two of them, about where the gun was, whose it was. They both said it wasn't theirs. And the fact that he missed court and had a bondsman, and that bondsman had to get a bounty hunter to get him back here. And the fact that he's from Florida, was apparently working supposedly in Louisiana and driving through here to sightsee in Houston when he was arrested, gives me concern about all of that. And so at this time, I'm going to deny the motion to reduce the bond. The bond will remain at $100,000. I'll reset the case for an announcement, and we'll get it moving in whatever direction it needs to at that time. All right.
I was just trying to say, I wasn't never arrested whenever she pulled me over. I wasn't arrested at all.
When?
When she initiated the pullover.
But you had a bondsman, so at some point.
That was after I had found out I had a warrant.
Right.
And I was keeping up with my bondsman. I texted her and said I was trying to.
Here's the thing, she's here, so be careful what you say. I've already made my ruling. You can go back with the bailiff. Okay, thank you, Mr. Rojas. Good morning. Are you Heriberto Chavez?
Yes.
And in cause number 25, DCCR 0559, Mr. Chavez is charged with deadly conduct, discharging a firearm from May 8th of 2025. What is the announcement?
We signed a rejection.
Oh, I'm sorry. Mr. Chavez, what that means is that if you go to trial and you're found guilty, the range of punishment is a minimum of 2 years up to 10 years in prison. Do you understand?
He understands, Judge. He thinks the offer is too high right now.
So the state, I have on the computer tablet a plea bargain rejection that has your signature on it, that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison. It says or, but.
I think we had been discussing a possible cap, Judge. I think that's
Okay. Just the 6 years.
Today was an offer of 6 or the caps. Was my
What was the
understanding.
cap of what? Y'all
You
talked about?
didn't write it
I
on
didn't,
there.
I'm sorry, it should be 8.
Or a cap of 8 years in prison, which is where you would leave your punishment up to me. I could not give you more than 8. I could give you 8 years. I could give you less. You have an absolute right to have a jury determine if you're guilty or not, and for that jury to determine your punishment if you're found guilty. I want to make sure you understand what the possible consequences are if you go to trial, and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? Do you have a question?
I want to try, but I don't want to accept the offer right now.
Mr. Nichols, is there any reason to believe that the state's offer would change?
No, Your Honor.
So you don't have to like the offer, but the offer is what it is. So your option is either to let a jury decide or to accept that offer. And so what do you want to do?
Wait.
There's no waiting. You have to make that decision today.
Try.
All right, I want to make sure you understand that after today, I won't accept that plea agreement. And do you understand that? Answer out loud.
Yes, after today, you won't accept that agreement.
Okay. Mr. Chavez will get your case set for trial. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial quicker. Is that okay with you?
Yes.
All right, so Mr. Rojas, you're released. Mr. Chavez, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Good morning, are you Lee Coney?
Yes, ma'am.
And Ms. Coney, you've got two cases. One you're on probation for in cause number 24 DCCR 1600 on probation for theft of property with previous convictions. There's a new indictment that's been handed down in cause number 25 DCCR 1274. You're charged with possession of a controlled substance, also a state jail felony. It's my understanding that there is no agreement in either of these cases. Is that correct?
That's correct, Your Honor. I was speaking with Ms. Coney this morning and yesterday, and she has a request to make of the court. She would like to have a new attorney.
Well, Ms. Coney, you don't get to pick a new attorney. Mr. Rojas is an excellent attorney. He's, I'm sure, talked with the assistant district attorney, is giving you that information and advising you. And so if you want to take some agreement, that's fine. If not, what's going to happen is today we'll go through that motion to revoke your probation. And I'll get pleas of either true or not true to those allegations. Then we'll reset that case for a sentencing hearing. I'll determine if you violated your probation. If I determine you have, I can either continue you, I can revoke you, I can do whatever at that point. And then depending on what happens on that case, I guess we'll see what happens on that new offense. And so do you want to talk to Mr. Rojas about that agreement, or do you want to go forward and leave it all up to me on your motion, I guess?
I plan to go forward.
With what? Just pleading open to the court?
Yes, ma'am.
Raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you. Will she waive the formal reading of the motion?
She will, Your Honor.
Ms. Coney, in 24 DCCR 1600, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2024 for the state jail felony offense of theft of property with previous convictions, and that was a 5-year deferred probation. Is that correct?
yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, a state jail felony, November 1st of 2025. And is that true or not true?
No.
Count 2 alleges that you committed the offense of possession of a controlled substance, penalty group 3, and I'm guessing that's a misdemeanor
I
offense?
think so, Judge. The case is not yet, that case has not been filed.
Okay.
It's awaiting testing right now. It's in progress.
Okay. And I'm not sure if that's a misdemeanor or not then. Penalty group 3, less than 28 grams on November 1st of 2025. And is that true or not true?
I'm sorry, what was it?
It's the same date. It's just a different drug. November 1st of 2025, when you were arrested, it was for possession of 2 different types of drugs.
No, ma'am. No,
Okay,
it's
so not true to count 2. Count 3 alleges that you failed to report to the probation department July 24th, August 21st, October 8th, and October 29th of 2025. And is that true or not true?
I'm sorry, he was trying to tell me something while you were talking.
So count 3 alleges that you failed to report to the probation department on July 24th, August 21st, October 8th, and October 29th of 2025.
That's true.
Okay. Count 4 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance. Mr. Nichols, did you read that one?
Failed to never become intoxicated or be under the influence of any intoxicating substance.
And that on or about
March.
the March 19th, 2020.
I'll just drop 4, Judge.
Do you want to, I mean,
This isn't my file. I don't know the details
Well,
of the
let's don't-
violations, and I can't amend right now.
Okay.
I don't know what,
What I'm going to do is, at this time, I don't want it I want to know whatever allegation that is at the appropriate
I
time.
can see it here, Judge, and I can orally amend that. What it's supposed to allege is that she tested positive for cocaine on March 19th, 2025.
So any objection to the amendment reading in that on or about March 19th, 2025, the defendant tested positive for cocaine? Mr. Rojas?
No objection.
So count 4 alleges that you failed to never become intoxicated or be under the influence of any intoxicating substance, and that you tested positive for cocaine March 19th of 2025. And is that true or not true? Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Not
Count 6 alleges that you failed to submit to alcohol and/or drug screening on July 29th of 2025 at the direction of your probation officer. Is that true or not true?
It's true.
Okay, you'll get to explain later. Right now, just true or not true. Count 7 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? I'm sorry?
True.
And then count 8 alleges that you are behind in your court-assessed fees as of November 3rd of 2025 in the amount of $575. And is that true or not true?
As of November. On that day, we know.
Yes, that's true.
Okay. Did you enter your pleas of true to counts 3, 4, 6, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true?
Well, with the payment, that my payment is caught up now.
Okay, I'll just take off number 8 and put not true on that one. So 3, 4, 6, and 7, did you plead true, again, freely and voluntarily?
Yes,
And because those counts are actually true?
yes.
All right, then I'm going to find counts 3, 4, 6, and 7 true, find that you entered those pleas freely and voluntarily, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset the case for a hearing. I would anticipate, Mr. Nichols, that you would have some evidence with regard to the count 1, the new
Yes, Your Honor, the
offense.
state will prove up.
Do you think we would need more than an hour or
I
so?
wouldn't think so, Judge.
Okay.
Appears to be a traffic stop.
One or two, I guess, a 2 witness.
Yes.
We need
At least
lab.
2. Hour and a half, I would think.
Judge Raquel West's strict decision sent a clear message in the courtroom today. With a $25,000 bond, mandatory GPS tracking, and a complete driving ban, the court emphasized accountability and public safety above all else. The case now moves forward, but this ruling has already become one of the hearing's most talked about moments. Stay tuned for more courtroom updates and breaking legal news.